If you get injured off tower or off watch, is that covered under the Jones Act? My name's Tim Young. Our law firm here in New Orleans represents exclusively injured maritime workers. If you're injured while you're off tower on an oil rig or off watch on a vessel, a lot of our clients will ask, does that mean that I can recover under the Jones Act or maritime law? Essentially, yes, if your company did anything wrong to cause or contribute to your injury. And let me explain this in a little bit more detail very briefly. What this means is even though you may work 6 a.m. to 6 p.m. and you're off duty from 6 p.m. to 6 a.m., if you get hurt during that off time at night, you absolutely can file a case under the Jones Act. You simply do need to still prove, like any Jones Act case, you do need to simply prove that your company did something wrong or they could have prevented your accident. So call us if you have any questions about your particular situation. The same thing applies on vessels. If you're off watch on your vessel and something happens in the galley or up in the wheelhouse, if the company is at fault and they could have done something different to prevent or maybe minimize your accident or your injury, then you do have a claim under the Jones Act. It doesn't make any difference whether you're actually out on the rig floor working at the time or whether you're inside in your bunk room or somewhere else off tower. Same thing when you work on vessels. Call us if you have any questions about your rights under the Jones Act and whether or not your particular injury may apply to the Jones Act and what you can recover.